So, is an audit a good idea and how might it actually work? Kim Rubenstein is an expert in citizenship law at the ANU College of Law, and we spoke many times during the whole High Court process. It's lovely to have you back. Thank you for coming in tonight, because now it's a question of, firstly, whether you think an audit is necessary.
Look, I certainly think each and every member of Parliament needs to identify for themselves whether they are eligible to be sitting in Parliament.
That requires us to trust them to do that.
Well, I guess there are two levels to the notion of audit. One is to actually make clear what their citizenship status is and how they go about doing that, and who would they report to in terms of an audit. Now, at the moment, when you nominate, you actually have to sign a form, as we know. That was part of a lot of the discussion in terms of the facts that people had signed to say that they were eligible to run.
It says very clearly on that form, are you in breach of Section 44. It even reminds people what Section 44 says.
But it doesn't actually explain what the High Court has since explained about what that actually means if you might potentially hold another citizenship.
That's a good point. It doesn't say you better check with mum and dad.
Exactly. So maybe the most straightforward way is for the Electoral Commission now to be updating its forms, although you would think anyone who has been paying attention over the last little while, but for further down the track, because of course in 1992 there was a similar discussion about who would be eligible when the last
well, that's a good point. So the Electoral Commission, this is for future parliaments, could say at the next election, if you're nominating to be a candidate and have a parent who was born overseas, make sure you've checked.
Well, there are a few things. If you were born overseas, if you had a parent, yes, but the different ways in which it is normal, or if you have some connection to another country that may give rise, and it's your duty now to check, because some people, for instance, form connections with other countries by going and living there for a substantial period of time, and there might be aspects of that getting married in another country that might lead to some rights.
Well, that's a good point. There are various ways you can get that dual citizenship. But for this Parliament...
For this Parliament, I think we have come to the point where there needs to be some, even if it's a one-off type of assessment, where individuals put into some body or some neutral as opposed to political point at, if they have a parent who was born overseas, the various bits of information that show that they've taken all steps that is reasonable on their part to renounce that other citizenship.
And look, you've heard the Prime Minister's argument that this would be, what did he call it, a genealogical research on every member of Parliament, an extensive search into foreign laws.
I think you see, this is where I think there's also been a misconception. It's not that you as an individual have to do that research. You just have to go to the embassy or the country of which you feel that there's a connection. It's not for you as an individual. Not everybody's an expert in those laws. All it requires you to do is to go to the appropriate authorities to find out that information. So it's not as if individuals are doing that genealogical study. Most people have the factual information as to who their parents are or grandparents, and if they don't, then they're not really going to be caught by this. This
is where an audit could do that work. You could have an independent body, and I'll come to who that might be, go through each MP and say, your mother was born there, your father was born there, and then we'll go off and find out what the situation is.
Yes, that could be that, but that probably would be a lot of work for a body such as that. And I wonder if more onus could be put on the individuals to submit information which
documentation
to show
so go off and get it themselves, and then submit the documentation.
Yes, indeed.
To an independent audit.
Yes, I think that is doable. I don't think you would want that to be the practice though for every Parliament, and it does raise questions in terms of the notion of nomination for Parliament, and then when you are a member of Parliament, the other section, which I was just discussing with you before, the follow-up section, Section 45, says that if something, while you're a member of Parliament, if you become someone who's subject to the disabilities in Section 44(1), you have to vacate your seat. So there may be a scenario where someone who has rights to citizenship by descent that are then placed on them without their application, that theoretically could fall foul under Section 45. And what process could you possibly have to be checking on everybody's citizenship to see if there have been changes of laws to do with descent?
But I like your approach here. It's essentially saying every politician go off and check. You don't have to make it public, where mum and dad were born and whether there's a dual citizenship issue, but you have to convince this independent assessor or auditor, and once they give you the tick, then we all know that.
Or could be submitting that information to the Australian Electoral Commission in the same way that you sign off that form as to becoming, that you are eligible. So,
but you'll need someone, whether it's at the Electoral Commission. I mean, there's been suggestions from the Greens of having a judicial officer. What about the Australian National Audit Office?
Well, I think each of these sort of independent bodies are entirely appropriate if they were properly funded to be involved in that sort of process. Absolutely. It is about enhancing, I guess the basic principle is enhancing our system of representative democracy, of a rule of law country which says we have a constitution, we have to follow it. We've seen this scenario, which is an unusual scenario, but that many members of parliament, well, not so unusual as I said to you the first time, because we now live in a multicultural society, and that's a much broader question about how appropriate this is.
And I want to come back to that because it's worth returning that. But
yes, I think that's right.
You could do it in this way.
Yes.
They may need, some sort of citizenship expert, or do you think that the politician would?
So I think it would be, the onus would be on the politician to go to the relevant country's authorities to find out, to gather that information to ascertain whether they are in fact a citizen of that other country. I think that is a reasonably straightforward step which anyone who's now thinking about nominating for Parliament should be doing as a matter of course. So what's wrong in asking all members of Parliament, now that this has become clearer, to do something that they should have done when they nominated for Parliament?
It may be the odd situation that's difficult to establish.
But in those scenarios where it is difficult to establish, the High Court's been pretty clear in terms of foreign law cannot preclude you from your constitutional right to run to be a member of Parliament, which means that if it is impossible to determine whether you are, and you've got documentation to show that country is so difficult to ascertain whether you are or not a citizen.
Sam Dastyari had trouble with Iran, for example.
But that's right. But he did follow through procedures so that he was able to satisfy both his party for pre-selection and arguably a court, if it were to look at it now, that he had followed all steps that were reasonable for him to nominate. That is, in essence, what every member of Parliament should have done. And so asking them to do that now is not an unfair request, given that they should have been doing it in the first place. And many of them may have, so it might be a very straightforward step for many of them.
Now, the longer-term solution here, you have long argued from the outset of this that the Constitution itself needs to change. We just heard Barnaby Joyce. He reckons you should still be prevented from sitting in Parliament if you're born if you have dual citizenship because you're born overseas or actively take it out. But if you had no idea, you inherit it, you were born in Australia, that should be fine. Would that be a fix, or are you saying just get rid of it altogether?
Well, I don't think it's a fix because I don't think it's consistent about what it is that we're trying to protect in terms of that section. And that what I understand that section and what I think most people understand is if you are in a situation where there is a direct conflict, you cannot represent Australia at the same time as properly being a citizen of that other country. And I think they're very narrow circumstances. I don't think it's about a sense of connection or loyalty that might possibly put you in conflict, because every human being, whether they're a national of another country or not, may have connections to other countries that might also be relevant when they're members of Parliament as to how they assess a particular piece of legislation going through, or a free trade agreement or so forth. So I don't think formal citizenship is any longer the actual benchmark for making those decisions. It only is if it actually, that citizenship forces you into a scenario where you are placed in conflict. And this is what was discussed before the court about a duty. So if you're a citizen of a country that if you went to visit it, you would be called up to do army service, then that is actually giving you a direct tension, because you can't be serving in the army if you're a member of Parliament, for instance. Or if you are a citizen of a country that is directly, that there has been a declaration
of war. So how do you get around that? If you remove this
44,
element of Section 44...
Yes, you would introduce into the Electoral Act provisions to do with disqualification once you're a member of Parliament, because I think the nomination step is no longer relevant. I think it is in essence, if you're a member of Parliament and a scenario or a situation arises where you're going to be in direct conflict, or if you are running for Parliament and you're a citizen of a country that is requiring you to give army service. Those sorts of...
Okay, so you would say change the Constitution and then...
Repeal that section.
That section. And then a dual citizen can be elected to Parliament they already make an oath or of allegiance when they take up their seat in Parliament.
Yes.
And then you could also have a law that says...
provisions for particular circumstances where you become disqualified, in the same way that Section 45 at the moment has a provision that there may be circumstances, for instance, if you become bankrupt or if you're found guilty of treason. There are certain things...
Do you accept politically, though, a lot of Australians aren't going to want any dual nationals?
Well, I don't think so. I think this is the standard response by a particular section of the community. But you think about the number of people who have a connection to more than one country in a country that is multicultural. I think that there would be... Once you explain to people what the issues are, and I guess you need that bipartisan support, and maybe the circumstances of this unusual scenario will lead to the bipartisan support, and perhaps for different ulterior motives. But I think the underlying issue is one which is about a coming of age in Australia in terms of recognising that citizenship is more like parenthood rather than marriage. So I may have used this with you before, but it's certainly something that I think makes people understand the concept. If you think of citizenship like marriage, then we all think, obviously, of monogamous relationships. But if you think of citizenship like parenthood, which I believe it is much more relevant to, you can have more than one child without that undermining your sense of love and connection to your children. You can stay committed to both without that having an inherent conflict. It's only when there is a direct conflict between them that you are placed in that situation as a parent that you might have to make a decision. And I believe in the same way you could amend the Electoral Act to say, if there is a circumstance of direct conflict, not presumed or conflict, but an actual direct conflict, it's only in that situation that you have to make that choice to be a Member of Parliament. And finally, I'd say, remember, in every other respect in Australia, you're entitled to be a dual citizen. We changed the Australian Citizenship Act.
In the state parliament, for example.
Well, that's right, too. But if you think about your parliament representing the laws of the country, we've changed the laws to enable all Australians to be dual citizens. It used to be that only people who had another citizenship first and became Australian could keep it. And if you were Australian and you took up a new citizenship, you lost it. Like Rupert Murdoch, when he became an American, he lost his Australian citizenship. But in 2002, we changed that and said any person...
Be a dual citizen.
Exactly. So if you can be a dual citizen, and we recognise in a globalised world that we can have multiple connections without that undermining our Australian citizenship, why can't we take that to the next step?
I think the Governor-General can too.
Yeah, well, there you go. Yes.
It's been always fascinating to talk to you.
Thanks, David, and likewise.
Thank you so much for joining us tonight. We're going to take a quick break. We'll be back with Paul Kelly. Don't go away.
Oh.